So thank you for joining us this evening. My name is Julia Robbins. I'm a Senior Vice President with CAMCO. With us this evening, we have Jonathan Katz, who is here to present on collections and mainly based in New Jersey. We were just discussing before the meeting. I said we're going to mainly have our New Jersey clients here, and he said that's good because he mainly works in New Jersey and not for our Pennsylvania clients as well. So he's got a great presentation for us this evening. And if you do have questions, we have a small group, so feel free to interject questions you may have or put them in the chat, and I'll make sure that Jonathan gets the questions. So without further ado, I'll turn it over to you.
Thank you, Julia. I'm going to share my screen, everybody. So hopefully this will work. Nope, that's the wrong screen.
Nope, that's right.
Oh, that was the right screen?
Yeah.
All right, hold on. Let's try that again. All right, how's that?
Perfect.
Okay. So again, thanks to Julia and thanks to CAMCO for having me today. As Julia said, I am primarily a New Jersey attorney, although I'm admitted in Pennsylvania. I've appeared in Pennsylvania court exactly twice. My firm, Wallack, actually has a Pennsylvania office. So if we need anything done in Pennsylvania, I'll usually ask one of the very capable attorneys over in Pennsylvania to handle it. And I primarily stay over on this side of the river, unless I'm going to see a Phillies game or an Eagles game or something like that. So just real quick about me, I am a partner at Wallack. We are a full service law firm, approximately 80 attorneys. We have 15 now attorneys in our community association practice group. I have been practicing in this area of law for a little over 15 years at this point. Handle everything from general representation of community associations to litigation, to transition, to drafting governing documents, rules, contracts, and of course, collections, which we're going to talk about today. So let me just give you my legal disclaimer. So very quickly, I am an attorney. However, I am not your attorney and I'm not acting as your attorney today. So just keep that in mind. If you do have questions, I'm happy to answer them. So you can feel free, as Julia said, to either put it in the chat or unmute yourself and just interrupt me. However, just please know that I'm not acting as your attorney today. And you should, if you have any specific questions, ask your association's attorney for his or her opinion on those issues. So that being said, we're going to talk about New Jersey collections today. So I want to really hit on three things which I think are very important in the 15 plus years I've been handling collection work. First is why every association needs a collection policy and needs to follow that collection policy. The next is we're going to go step by step as to the community association collection process. Prior to becoming a community association attorney, I did collection work for some other companies. That was medical bills, credit cards. It's a little bit different. Some of the issues are the same, but again, community associations are their own animal. So of course, things are going to be a little bit different when handling collections in the state. And then finally, I assume we'll have enough time to talk briefly about some foreclosure and some bankruptcy and what I'll consider to be more advanced issues for things that, hopefully your association doesn't have any issue with. But invariably, we always run into situations where someone files for bankruptcy, someone's in foreclosure, or the association wants to start their own foreclosure on any specific individual. So let's move on and start talking about collection policy. So it is my recommendation, and I strongly recommend this to every association that I represent, or when I meet with a new client or potential client, they should have a collection policy, along with a number of other policies, whether it's regarding parking or dispute resolution or confidentiality, those type of things. Collection policy is one of the most important things you can have. If you do not have a collection policy, you should speak to your attorney about adopting one. They can be fairly basic, just kind of what, and I'm going to go in the next slide is going to talk about what should actually be in the policy. But what it does is it allows you to basically have a consistent procedure for how collection matters are going to be handled. It's good so the board knows how the collection process should work. And it's also good because the owners will understand what will happen if they do not make their payments and what they can expect. And finally, it's important to enforce the collection policy uniformly. That doesn't mean that each individual situation can't be decided on its merits. Sometimes there are reasons why you would be more lenient with one person than another. However, it is important to enforce consistently, whereas you're not sending one person into collection and then someone owes more or less or money and you're not sending them into collection. So you want to be careful about enforcing your collection policy uniformly. So what should a collection policy have? Number one, it should address when to begin collection. Generally, depending on how your association operates, people are going to get a late letter after they are a month late. They may get one or more letters from management telling them that they're delinquent. Most of the time, associations will send accounts to me. Again, depending on how much the monthly assessments are, sometimes it's after sometimes it's after 60 days, sometimes it's after 90 days, sometimes it's after 6 months, depending on those associations. I have some associations that only bill once or sometimes twice a year. So the amount doesn't get over $500 until they've been delinquent for a year. Those are usually the ones that are more difficult to collect. It's easier, in my experience, to collect once you start the collection process sooner. So once they've gotten their 1 or 2 letters from management telling them they're delinquent, my recommendation is to get it over to your legal counsel, to your attorney, so they can start the process, because sending out that initial legal letter first, within the first, let's say 90 days, really does have better results in the long run. So that's when to begin collections, when to refer to counsel. The policy is also going to discuss when late fees will be applicable, interest in certain circumstances. A lot of older governing documents, a lot of older associations don't allow for late fees. They only allow for interest. So you have to take a look at your documents to make sure that you're authorized to either charge late fees or charge interest. I've even seen some documents that don't allow for attorney's fees or allow only for a certain percentage of attorney's fees. That's one of the things that you're going to want to talk to your attorney about before you start the collection process. If necessary, you can propose an amendment to your documents to add those things. Acceleration of assessments is something that I get questions about all the time. Most documents will include acceleration. And what that means is, even though in most cases you are authorized to collect your assessments on a monthly basis, sometimes it's a quarterly basis, you're basically, when you adopt a budget for the year as a board, the board is adopting that budget for the full fiscal year, for the full 12 months. And then that assessment, again, as long as the documents allow for it, is paid over the course of those 12 months. Again, sometimes, most times on a monthly basis, sometimes quarterly or bi-monthly, depending on how the documents are written. In most cases, you are authorized, you meaning the board, and me being legal counsel, are authorized to accelerate the full amount of the fiscal year pursuant to the documents. So when we are sending a letter, and we're going to talk about the letters that we send to these individuals. When you're sending a letter, one of the letters is going to say, pursuant to section X of the documents, we are accelerating your assessments through the end of the association's fiscal year. So whereas in one point they may have only owned a couple $100, now they may owe a couple $1,000. That's beneficial when we are recording liens and when we are moving ahead with either a money judgment complaint or foreclosure, which we're going to talk about in a couple minutes. So,
yep. Sorry to cut you off. We did have a question come in just asking what you recommend basically for a starting point to begin the legal process. Do you think it's best to start as soon as possible, such as 60 days, 90 days? I know a lot of them that I've seen is generally 90 days or 3 months.
Yeah. So the most, I would say the most common is between 60 and 90 days, but it really depends on your association and how much your monthly assessments are. Again, I represent a couple lake communities where they only, it's only a couple bucks for the year. I have one association where it's like $150 for the whole year. So in some cases, it may not make sense for them to send somebody to legal just if they, if they owe $150. On the other hand, if they owe $300, that means they haven't paid for 2 years, which is going to make it really difficult. In most associations where they're charging anywhere from, 100 to 200 to 300, whatever the case may be per month, I really do recommend, between that 60 and 90-day period, because the longer you let it go, the harder it's going to be to collect. And again, for some associations, we represent associations throughout the state of New Jersey. Most of my clients are in South Jersey, but I do have some clients up North Jersey and some, bigger high-rise clients. Some of those assessments can be upwards of $600-700. I have one association with upwards of $1,000 a month. Obviously, you're talking about considerable amounts of money that you don't want to keep on your books. You would rather try to collect it.
Great. Do you ever, just to bounce a question off of that, do you ever recommend a certain threshold? Say, like you were saying with the smaller dollar amounts, maybe if it gets to, whatever certain threshold dollar value, if ever used as a trigger as well?
Yeah. So again, some associations, again, it depends on the association. But I have associations that will set that amount, and sometimes they'll set it at 500. Sometimes they'll set it at 1,000 rather than the actual, just a month. I think it's easier if it's months, but I do have associations that will set it at, say, $500. And anytime anybody's over $500, we're authorized to send a letter out. It's a good question.
Yeah, thank you.
So again, collection policy is going to talk about acceleration. It's going to talk about what the association is going to do in recording a lien, whether they're going to take other legal action, whether that's a money judgment complaint, possibly a foreclosure. And here are two really important things. One is application of payments. And this sometimes gets me in trouble with the management companies, because management companies will always, I shouldn't say always, management companies will usually apply a payment to the oldest balance, although sometimes that's not the case. But if the association sets how they want their payments to be applied, that's generally how the management company will do it. And usually it will go to not necessarily the oldest balance, but it will go to legal fees and late fees and fines and other things before it would go to the actual association assessments or fees. And there's a legal reason for that. Again, it's not super important unless you get into a situation, which I've been in, unfortunately, where you're trying to collect from somebody and they've been making payments. They just haven't been making the full payments. So then when we go in front of the judge looks at the ledger and the ledger says, well, Mr. Katz, this is, $1,000 worth of legal fees and that's all that they owe. And I was like, well, that's true, Judge, but they've been paying and the association has been applying the payments towards the old balance, which is the maintenance fees. So sometimes it's just beneficial, especially when we're in court, to make sure that those payments are applied first to legal, late fees and other things rather than to the oldest maintenance fee. And the other thing regarding collection policy is you should address suspension of privileges. I'm going to talk about that a little bit later in the program, but most documents that I've ever seen, and if not, we can certainly talk about that, they authorize you, if someone is delinquent in their payments to the association, to suspend privileges. That could be the privilege to vote in an election, or for an amendment or some other thing that the association is voting on. It could mean suspension of privileges to use the amenities, the clubhouse, the pool, tennis courts, or it could be suspension of parking or other things. And like I said, we're going to talk about that. One of the things, I always hear from my managers is, right around when pool season starts, pre-COVID, everybody would want to make sure that they're paid up in order to get their pool passes. It's a smart way to try to collect from people who might necessarily won't want to pay, but they want to get their pool passes for the year. So let's talk about what actually happens when an account gets referred to me for collections. So again, when it comes to me, it's usually 60 to 90 days delinquent. Management has sent out their letter or two letters regarding what is late and what is not. There's been no response from the unit owner. I am required by federal law, a law called the Fair Debt Collection Practices Act, to send out a letter to the owner, giving them 30 days to ask for verification of the debt or let me know that they're disputing the debt. That is a federal law. And as a debt collector, I'm required to follow it. Management companies, as of right now, are not required to follow it. Associations, because it is your debt that you're trying to collect, are not required to follow it. However, so just so I don't get sued, that's one of those things that we're really careful about. The Fair Debt Collection Practices Act is a very, again, it's a federal statute. It's very important as part of our practice. It basically tells us a lot of things about how we're allowed to interact with debtors, things that we can and can't do. So we pay very close attention to it. So again, we're going to send that initial letter. We're going to have to wait that 30 days to see if we get a dispute from the owner. If we do get a dispute from them, we will send them what we call a verification of debt. It's usually a certification for management, along with a copy of their ledger explaining to them what they owe. If we don't get a response from them, then we move on. And generally what we do is we send that acceleration notice. So acceleration notice talks about what we talked about before. In acceleration, we're putting them on notice, which most of your documents will require, that if they don't pay the balance due within 10 days, we're going to accelerate their fees to the end of the fiscal year. And again, most documents require that we give that type of notice before we actually accelerate the fees. So the next step after we send those initial notices, if we do not hear from the owner or if the owner still isn't compliant, either contacting us for a payment plan or paying off the balance, is we would recommend recording a lien on the property. So what is really a lien? So a lien is a security interest that secures the property and the payment that is due it. So it indicates basically how much is due from the owner to the association. As I mentioned before, if your association authorizes acceleration, we're going to record a lien for the full amount that is due through the end of the fiscal year, plus anything that was due prior to that. So why do we record a lien? There's really three reasons. One is to prevent the unit owner from selling or transferring that unit without satisfying the balance. Some of you will say, well, that never happens. You know, they have to go through the title company. Trust me, I've seen it happen more than one time. Sometimes it just slips through. So all of a sudden it's like, well, I don't own that property anymore. I sold it last year. And those are the issues when, we wish we had a lien. Sometimes it happens when we do have a lien. But in most cases, when somebody, as long as they're doing their due diligence, they hire a title company, they're going to discover that lien as part of that title search, as part of the closing process, and they're going to be able to pay off the balance. Second reason why we record a lien is to secure what's called limited priority, and that's in case that there is a mortgage foreclosure. And I'm going to talk a little bit about that as we move along. Limited priority is a interesting concept. I don't believe it's something that Pennsylvania has, although I may be wrong about that. But a number of states do have limited priority statutes. New Jersey has had one for a number of years. It was just amended in 2009. It used to be only for condo associations, but now it is for both condo associations and homeowners associations. So that actually has been a good change in the law that's been enacted for the last 2 or 3 years. The last reason we would record a lien is to secure the amount due in the event a unit owner files for bankruptcy. We're going to talk about bankruptcy later on as well. But if the association has a lien or a judgment, that becomes a secured claim in the bankruptcy, which is something that will normally get paid back first before any unsecured claims. So if there's money that's due over and above the amount of the lien, that becomes unsecured, but the amount that is listed in the lien becomes a secure amount. And again, that's important when the unit owner may file for bankruptcy. So let's just talk about the distinction between liens. Again, this is different in Pennsylvania than it is from New Jersey. Pennsylvania have basically automatic liens. And for that reason, associations in Pennsylvania don't really have to record liens with the county. That's not the case in New Jersey. If you are in New Jersey, we record liens. And now because of the priority statute, we record liens, or we recommend recording liens every year. So what's the basis for an association being able to record a lien? Well, for condominium associations in New Jersey, it's authorized pursuant to the Condominium Act. The Condominium Act is the site is right there. It's also, in most cases, authorized by your governing documents as well. but sometimes the court will question the association's authority to do that. And for condominium associations, we could just point to the Condominium Act. So liens can include late fees, fines, attorney's fees, as long as they are authorized by the governing documents. However, the associations cannot record a lien solely for late fees. Homeowners associations, on the other hand, there is no statutory authority for liens. So they're only allowable if they're authorized by your governing documents. I've actually never seen a set of governing documents that hasn't authorized a lien, so you don't really have to worry about that. If your association isn't authorized liens, that is something that we should fix sooner than later. So let's talk about priority. So again, in 2009, there was a change to this law. It used to be just that associations, condo associations, were entitled to this limited priority. So when I keep saying that word, limited priority, what is it really? It's really a super priority, and sometimes it'll be referred to as a super lien or a super priority. And the reason is when you buy a house, you usually, if you're taking out a mortgage, that house is secured by a mortgage. That mortgage is going to be prior to, or it's going to basically trump anything that would come after it. So any type of judgment or lien that would be recorded after the mortgage is going to take priority over that. What this statute does is it creates a limited priority that basically trumps the mortgage. And what it used to be was, it used to be 6 months of assessments. So if you are charging $100 a month, it would have been $600 for the 1 year that you record the lien, so long as the association's lien is recorded prior to the mortgage company filing a foreclosure complaint against that unit owner. Again, that has changed due to that 2019 amendment to the law. So now the associations are entitled to 6 months of fees for each lien up to 5 years. So potentially it went from $600 to $3,000. So it's been a huge benefit to a lot of our associations. It's also the reason why I mentioned before that we highly recommend that associations update their liens every year, because they're going to be entitled to that additional 6 months for each year they have a lien up to 5 years. So again, this priority is only for the monthly assessments. It's not for any late fees. It's not for any attorney's fees. It's not even for any special assessments. So if you had to do a special assessment for snow or something else, that's not included. It is specifically only for monthly assessments. The other thing which I mentioned before is this law, the super priority law, only applied to condo associations until 2019, when the law was expanded. So it now also covers homeowners associations and condo associations, which again, sometimes the law changes for our benefit. In this case, it certainly did. So let's talk about money judgment complaints. Whereas a lien is recorded against the property and not against the person, a money judgment is a personal judgment against someone for a certain amount of money. So the question I get all the time is, why do we recommend a money judgment rather than just a foreclosure? Because associations are allowed to do both or either. And the reason is there's a couple reasons. One is because money judgments are both quicker and much, much less expensive than pursuing foreclosure. So most of the cases that we handle are filed in the special civil part, which is essentially the small claims division of the New Jersey courts. There is a monetary limit. It can be from $0 up to $15,000. Again, if you're starting your collection process sooner rather than later, hopefully you're not going to hit that $15,000 threshold. For some associations that don't start it as quickly, or for their assessments are higher, we basically have to file that in a different court in the regular civil part as opposed to the special civil part. And the reality of the situation is it's the same process. It just takes a little bit longer and it's a little bit more expensive. Another benefit of special civil part is the court serves the documents as opposed to us having to serve the documents. Again, it just saves the association a little bit of money. We're able to obtain a judgment faster. Again, usually If the owner does not respond, we can get a judgment within 90 days. And it may be one of the best options if there is already a mortgage foreclosure or if there's some reason why we wouldn't be able to collect. And we can in some circumstances sue a non-owner, whether that is a tenant or a spouse, but that really depends on the circumstances and gets into the more complicated issues of why we wouldn't be able to collect from the actual owner of the property. So what does the association need to prove when we file a money judgment? Well, it's basically only three things. One is that the owner is the actual owner of the unit. The second is that the association levied an assessment that hasn't been paid. And that's it. Those are the three things: that the person's an owner, that the association has a valid assessment, and that the assessment hasn't been paid. So once we get our judgment, and again, this is a personal judgment against someone, it's not against the property. How can we collect it? Well, there's a number of different ways. Some of them are easier than others, and some of them are more successful than others. The most successful are those first two. It's either a bank levy or what we call a wage garnishment, a wage execution. Bank levy is exactly what it sounds like. We get the judgment, we ask the court to assign a court officer. The court officer goes out with what's called a writ and serves the writ on a bank. If there is money in that bank account, the bank freezes the account. We then file what's called the motion for turnover, and then we get the money minus the court officer's commission. Court officer's commission is actually over and above the amount of our judgment. So if we have a judgment for $10,000, court officer is entitled to 10%. He or she would actually collect $11,000, take $1,000 off the top, and we would get our $10,000. It's a very efficient way for us to try to collect when we know where someone banks. Again, we have an investigator who's able to find that, and we're going to talk about later about certain things that you as board members can do to try to help with that process. Similar issue with wage garnishment. Unit owners who are working, we can ask the court to issue a writ. That writ is then served by the court officer on the employer. The employer is required by law to garnish the employee's wages. Generally, that's 10% of their net wages. It can be less than that at a judge's discretion, but generally we're talking about 10%. So those are the two most popular ways to collect on judgments. There are a couple other different ways. One is a rent garnishment. If the unit is rented, obviously, we can ask the court officer to levy on the rents. That is sometimes successful, sometimes not, because sometimes the tenants will put up a little bit of a fight and then we have to put a little pressure on them, but that can be successful as well. Personal property writs used to be much more successful, I'll say maybe 15, 20 years ago. And that's where we would ask the court officer to go out to an individual's home and basically threaten to sell their car or their personal property. Quite frankly, court officers don't want to do that anymore. It's a risky proposition for them. So most of them won't do that. Based on the judgment, we can also have the unit owner arrested or at least threaten to have them arrested until they fill out what's called an information subpoena to let us know where their assets are, where they bank, where they work. It's been a long time since I've actually had anyone arrested, but we actually file a lot of motions to enforce litigants' right, which basically threaten that. And what happens is they have to show up at the courthouse and fill out the information subpoena. If they don't, they potentially could be arrested. And the last thing we can do is if we can't collect any of these other ways, we can actually use the judgment to either have the court appoint a receiver. So, and sometimes we use that where a unit may be vacant, or we can actually try to sell the property. And it's kind of like, I'll call it a short circuit to the foreclosure process, because like I said, foreclosure is a expensive process and it's a lengthy process. So this is a way for us sometimes to short circuit that, especially when a situation where the association just wants to get out from under a certain amount of debt and possibly sell the unit. So we've talked about a lot of things. Does anybody have any questions so far? How am I doing, Julia?
Wonderful, thank you.
All right, I'm moving right along. So let's talk about foreclosure. Again, so a money judgment is a personal judgment, but a foreclosure is not. A foreclosure is against the property. So the way the foreclosure begins is we would record that lien, and a lien essentially would operate as a mortgage. One of the things that your documents probably say, because 100% of all the documents I've ever seen say this, is that the association has the ability to foreclose a unit in the same process as a mortgage foreclosure. So you are essentially using that lien we are recording to then foreclose on the property. So what are the pros and cons of doing a foreclosure? Well, the only defense to a foreclosure is payment. So if they can pay it, then we would have to dismiss the foreclosure, but they really have no other defenses to the foreclosure. In some cases, it's going to be the association's only option. And usually that happens when someone passes away, when someone moves out of state, we can't find them, sometimes moves out of the country. And it may be the only way for the association to be able to collect anything going forward. And also it may result in, depending on what happens at the actual sheriff's sale, it may result in the association taking title to the unit, in which case, in some cases, we can sell the unit, but more likely we will be able to rent the unit to try to recoup the amounts that are due. So what are the cons? The biggest con is that it's, again, like I talked about before, it's expensive and it takes a lot of time, usually about over a year, sometimes closer to 16 months, sometimes closer to 2 years. But it's also foreclosures, association foreclosures are subject to the existing mortgage. So if a unit has a mortgage, we're going to be taking title, or someone is going to be taking title to that property if it goes to sale, subject to that existing mortgage. And all that means is that the mortgage doesn't go away. The association, if they do take title to a unit through a foreclosure, the association is not responsible for paying that mortgage. But what it means is that the mortgage, the person who owns the unit is probably going to stop paying their mortgage, and the mortgage company is going to start their own foreclosure. So sometimes we have a short window in which to try to actually collect the monies that are due. So how do we start foreclosure? Well, we begin the process of sending what's called a notice of intent to foreclose. It's kind of like our initial collection letter. It basically puts them on notice that, hey, if you don't take care of this balance, we're gonna foreclose on you. A lien should be recorded prior to us starting the foreclosure to make sure that we have the full amount is secured, and we would accelerate that lien if possible. Once we get a final judgment, and again, like I said, that usually takes between a year and 16 months, we can schedule what's called a sheriff's sale. And like I mentioned before, if the association does take title to the unit, it's still subject to the existing mortgage, but however, we may be able to rent or sell the unit depending on the circumstances. So that's foreclosure in a nutshell. Again, we foreclose on a lot of units, but it is sometimes a last resort. And there usually is a very good reason why we would recommend that as opposed to another method of collection we talked about earlier. There are a couple other ways, other alternatives to foreclosure. So we've had situations where we've had unit owners who have moved out of state and the unit's vacant. They have voluntarily entered into agreements to allow us to rent the unit, use those monies to pay down the balance. Sometimes we will take a deed in lieu or have the unit owner sign a quitclaim deed. So again, the association can either rent that unit or possibly sell it. Rent receiver or judgment receiver is basically getting an order from the court, allowing the association to rent the unit prior to any sheriff's sale, prior to the association taking ownership of a unit. I'm sure some of you have heard the term short sale. That's essentially when a mortgage lender is allowing a unit owner to sell the unit for less than the full amount of the mortgage. Again, it's important when the association has a lien in that situation, because we can really take control over whether or not we let the short sale go through. In most cases, the mortgage lender and the owner are going to try to pay less than the full amount due if there is a short sale. So we can help you negotiate that. Again, sometimes it makes sense to try to get a non-paying owner out of the unit to get a paying owner in the unit. So in some cases, we may recommend taking less than the full amount. But I will tell you that you should never, ever take the first lowball offer that you get from a lender who's trying to go ahead with a short sale. Lender in possession action is something that used to be a little bit more prevalent. There's been a change in the law over the last couple of years. And so lenders are actually smart about doing this. They usually don't put themselves in a situation where they're actually going to take possession of a property prior to it being taken over by them in a sheriff's sale. So we don't really see that too much. Okay, let's talk about bankruptcy. Bankruptcy is one of the, I'll say it's probably one of the most confusing aspects of collections. It's so confusing sometimes we actually have our own department here who handles our bankruptcies for us. I know enough about bankruptcy to make me dangerous, so I'm going to just try to give you a little bit of flavor for what bankruptcy is. So there's basically two types of bankruptcies that you may see as an association. A Chapter 7 is when a unit owner is seeking a total discharge of his or her debt. A Chapter 13 is when that unit owner is reorganizing the debt. A 13 usually takes around 5 years, whereas a 7 can be as quick as 3 or 4 months. If a unit owner files a 7, in most cases, we are not going to see much or any of that money. However, if the unit owner files a 13, there's a good chance we are going to get a good chunk of that money, especially if we've recorded a lien for the full amount or close to the full amount. Once a unit owner files for bankruptcy, there's an automatic stay that's entered by the court. What that means is we can't take any collection action against them unless the stay is lifted or unless their bankruptcy is over. Why that's important for you as board members is it also means you can't deny them certain privileges. So if we have suspended Mr. Smith's privileges to use the pool because he's delinquent, if he files for bankruptcy and then he starts paying his, what we call his post-petition assessments, then we can't stop him from using the pool. That would be a violation of the bankruptcy stay. So that's important if you do that, if you are suspending privileges for certain people, you have to make sure that they're not being suspended for those that are in bankruptcy. Pre-petition versus post-petition. So again, the way that you actually file a bankruptcy is you have to file a petition with the court. You file that petition on a certain date, and that date determines what your pre-petition amount is and what your post-petition amount is. In 2005, there were certain amendments made to the bankruptcy code which clarified it and made clear to everybody that associations are entitled to be paid for the post-petition assessments. So that's any assessment that accrues after the petition filing date. There are some bankruptcy attorneys who will tell their clients that they are not responsible for that. That is incorrect. And we usually have to explain to them why that is incorrect. So again, pre-petition are the amounts that are due prior to when they file for bankruptcy. Again, in some cases, depending on what they file, we may be able to collect some or all of that. And post-petition are the amounts that accrue after the bankruptcy is filed. They should be paying that. If they're not, then there are certain things that we can do to try to get them to pay that. And the last thing I want to talk about in terms of bankruptcy is abandonment versus surrender, because sometimes we get a lot of questions from managers or from board members about this. When there is a bankruptcy, a lot of times the bankruptcy trustee will actually, they file paperwork which says they are abandoning a certain asset as part of the bankruptcy. That does not mean that the unit owner does not own that unit anymore. It just means that in terms of the trustee is not considering that unit, which is in your association, part of the bankruptcy. So if someone comes to you and says that we abandoned our unit, we're not responsible, legally that is not correct. However, if someone surrenders their unit as part of a bankruptcy, they may or may not be responsible for the fees going forward. So again, it's one of those things that we need to look at. If you do get a notice from the court saying someone has either abandoned or surrendered their unit, you should definitely talk to your legal counsel about what that means for you. Okay, let's talk about suspension of privileges. So like I mentioned before, there are a couple ways you could suspend privileges, whether it's for voting rights, whether it's for parking, whether it's for using the amenities. Before you do that, most documents require, and New Jersey law requires, that you offer, well, not all the time. Most of the times you're going to want to offer them what's called ADR, dispute resolution, mediation, before you are suspending those privileges, and certainly before you are issuing any fines to them for violations of your governing documents. So like I mentioned, if you're authorized, you may be able to suspend them for voting, parking, using the clubhouse and the pool. Excuse me. Suspension generally only applies to the common property, not to the member's own property. One of my favorite cases in New Jersey happened around 20 years ago, and one association decided that specific unit owner wasn't paying his dues, so they were going to put a big concrete column in front of his garage so that unit owner couldn't access his garage. Not surprisingly, the court said that you could not do that, but it's a great case. So just some issues to be aware of when you are suspending privileges. Like I mentioned before, if a unit owner files for bankruptcy, you have to be careful. You can't suspend those privileges if they are paying their post-petition assessments. And then if someone requests a reasonable accommodation because of a disability, you may or may not be able to suspend their privileges, even if they are delinquent. So you're going to want to talk to your association counsel before you do that with someone who you know needs closer parking because they have a certain disability, they have issues walking, whatever the case may be. So please speak to your association counsel before you would suspend somebody's parking, someone who's obviously in a wheelchair or needs some help getting around. So just a couple, yeah, go ahead.
Sorry, just a question on that. So with parking privileges, so I think it's fairly easy when a community has, say, designated spaces in their common area for certain properties. But what would you suggest for an association that just has like an open lot where people can park? Like I've heard, boards want to tow away vehicles if they note them in the parking areas, but what's typically the process for something like that where they don't have designated parking spots?
So do you mean like what is a board, like how do they tow out of that area, or I'm not sure I understand your question.
Recommend just like, I mean, we never really recommend just towing vehicles just in general, but
right.
Do say like for those that don't have assigned spots, if the vehicle's noted in a community lot that they can just tow it at that point if they're
Yeah, so that goes back to one of those policies, and most of my associations, I recommend a parking and towing policy, and that policy will specifically say if a unit owner is delinquent, as long as we would recommend at a certain point sending notice to them, and that notice basically says you can't park anywhere on the common property until you rectify your balance. So they would then be on notice. In New Jersey, there's something called the Predatory Towing Act, so you need to have certain signage, you need to give certain notice to each unit owner before you would be able to tow their vehicle. But as long as you're giving that notice, and as long as you can identify that as actually that delinquent owner's vehicle, you're allowed to tow it. So I do have some associations who do that. It's obviously easier when they have assigned parking because you're gonna know that if they park in that spot and you've given them notice that either them or their guests or their family or whoever can't park there, then they're not going to be able to park there. You're going to be able to tow. When it's just when all the parking is common, it's a little bit more difficult.
So you would recommend having it in that collections policy about the actual.
So I usually put it in both. So I usually put in the collection policy that if your privileges are suspended, you may be towed. And then again, most of my associations have for those that do tow, and again, not all of my associations tow,
right.
For those that do want to tow, there's a specific section in their parking and towing resolution, which talks about what happens if you're delinquent. The association will put you on notice and then they may tow your vehicle.
Okay, perfect.
Yeah, again, it's another good way to get people to pay up sometimes. They don't want to have their vehicle towed.
Right.
So last, but certainly not least, what can you as board members and what can managers do to help us with the collection process? First thing we talked about, turnover collection matters in a timely fashion in accordance with the collection policy. Again, normally we're going to recommend between 60 and 90 days, unless you're one of those associations that, may benefit from a monetary threshold like $500 or something else if you're not charging a lot in terms of fees. keep important documents, copies of emails, copies of checks, information regarding employment, because that'll just save us hassle down the road. Again, we can always find out that information. We have very good investigators to do that. But if you get an email from Mr. Smith and on the bottom of his email, it says he works at, Target, or he works at PNC Bank, that's very helpful for us in terms of trying to collect on that balance due. And then another thing that sometimes associations will do, and that's another resolution that we have, is make sure you're keeping tenant information, copies of leases. In some cases, we get associations to enact a resolution where both the owner and the tenant would have to sign what's called a lease rider. And that would allow the association to notify the tenant that, hey, your unit owner is delinquent, start paying your rent over directly to the association. That is helpful in some associations as well. So, actually went longer than I thought I would. I just talked and talked and talked. But if you have any questions.
Really helpful. So thank you.
So if there are no more questions, and again, I'm happy to take any questions about collections or anything else. Like I said, I've been doing this for a long time. So if you have any questions that are either collection related or non-collection related, I'm happy to answer them. If not, if you don't have any questions, or if you think of something later, please feel free to either call me or shoot me an email. My email's up on the screen. We also have a blog, which I wish I had more time to write for. I used to write more often, and it's so busy these days that it's hard to write sometimes. But if you want to.
Pardon me, I do have a question.
Sure.
To update a resolution or to do a resolution on the collections policy, is that something the board can do, like a rules and regulations, or can we do that under the more short form updating with what that, if you don't get the 10% opposition, which is much easier to update, or does it require the full 2/3 process because you're amending the controlling documents?
That's a great question. So the board has the authority to adopt just a collection resolution, which is essentially like a rule and regulation, as long as you're not changing anything in your bylaws. So for instance, if your bylaws say that you can charge a $10 late fee and you want to change that to $25, obviously that would require an amendment. And you can amend it, you can amend your bylaws using, what we call the Radburn 10% reverse process, or you can do it the traditional way, which normally requires either 51% or in some cases 67%. But as long as you're not actually changing anything in your documents, you have the authority, just as a board, to adopt a resolution regarding how you're going to handle collections.
Probably to add the acceleration, we'd probably have to do it by way of the Radburn method.
That's correct. If you do not have acceleration, you would need to add that to your bylaws as part of as an actual amendment. That's correct.
All right, sounds great. Thank you.
We did have 2 questions pop up in the chat. The first one is asking about Spurlonga. And Jonathan, I don't know if you're familiar with Spurlonga. It's a credit reporting.
Yeah. So I don't report to credit agencies, and part of that is because of that Fair Debt Collection Practices Act that I told you about before. I have had 1 or 2 associations who've used Spurlonga or other credit reporting agencies. Quite frankly, I don't know that it helps, but I don't have any opposition to it. Quite frankly, if it lets you help collect the balance due to your association, I'm all for it. My job as your collection attorney, at least, is to try to collect the money. And if that helps you collect the money, by all means, I'm happy to help you do that.
Great, thank you. We had one other that says, without a lease rider, can an association still garnish rent?
Yeah, so that's a good question. The answer is yes, as long as you have a judgment. So you can use the judgment. And again, the way that the process works is we get the judgment, we ask the court to issue a writ, the writ goes to the court officer serves the writ on the tenant. However, you can short circuit that process if you have a lease rider. So if you have a signed lease rider, that's a contract between the association and the owner and the tenant. And generally the way that my lease riders operate is you have to send one notice to the owner and say, owner, you have this lease rider, you signed with us. If you don't start paying the balance due, we're going to notify your tenant and we're going to tell your tenant just to pay us over the rent. And you can start that process way earlier than if you had to go through the whole process to get a judgment. So it's going to save the association a lot of time, and it's going to save the association a lot of legal fees. So you can still do it if you don't have a lease rider. It just is going to take you some more time to get that judgment.
Great, thank you. Anybody else have a question? All right. Thank you so much, Jonathan. This has been really super helpful for everyone, and appreciated it. For those board members who are with us this evening, we're also going to have another presentation by our friends at Wallack on, it's Thursday, September 1st, and that's going to be on governance specialized in New Jersey. So you'll go through some of what Jonathan touched on as well. And that will be with George Greatchecks, sorry, I pronounced it wrong, who is also a partner at Wallack. So please join us then as well.